LegalDoc talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. I got a copy of the actual signed courtroom order from the Carmelo Anthony trial, the one controlling media access, security, everything. And when you read it side by side with the legal test that's already reversed 3 Texas murder convictions this year, this order has real problems. Today, I'm walking through it provision by provision. I'm your favorite paralegal, aka Cassandra Lynn, and this is Legal Doc Talk. Now, before we get started, I just want to put my little disclaimer. This video is for legal education purposes only and does not constitute legal advice. Analysis is based on the publicly filed amended order regulating trial proceedings that was dated on May 18, 2026, and published Texas appellate opinions. Case developments may change rapidly. All individuals are presumed innocent unless and until proven guilty, and post conviction motions are a normal part of the appellate process. All right, so let's get into it. So, this is the amended order regulating trial proceedings, media access, security, and courtroom decorum. It was signed May 18th, 2026, by Judge John Roach in the 296th District Court in Collin County. It's the document that governs everything about who gets into the courtroom and how. And notably, the order itself cites Waller versus Georgia and Shepard versus Maxwell right in the opening paragraph. So the court knew this test applied. The question here is whether the order actually satisfy it. So let's take a minute and review the order. On this day, the court enters this order to govern, and now, mind you, this is the amended order. On this day, the court enters this order to govern all aspects of the trial proceedings in this matter. Due to the significant public and media interest in this case, the court finds that specific procedures are necessary to ensure the defendant's right to a fair trial and partial trial. The orderly administration of justice, and the safety and security of all participants, and the reasonable public access consistent with constitutional requirements. The court has considered the directives set forth in Waller versus Georgia, the 1984 Supreme Court case, and Shepard versus Maxwell, 1966, as well as all applicable constitutional provisions, statutes, and case law. The court finds that this case has generated substantial public and media attention and that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. The court further finds that reasonable time, place, and a manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to the limitations set forth in this order. The courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. for members of the media and at 8:40 a.m. for designated family members and at 8:50 a.m. for members of the general public. No more than 9 members of the media shall be permitted in the courtroom at any one time. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 a.m., and individuals arriving that time shall not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re enter during proceedings except during a recess. The determination of who qualifies as a member of the media, which media representatives will be permitted access to the courtroom, and the allocation of media seating shall be made with the assistance of the court appointed public information officer for the court. Media representatives must comply with all credentialing requirements established by that officer. The court will not intervene in or resolve disputes among members of the media regarding access or seating. The court has appointed Steve Stoller as the appointed public information officer, Stephen L. Stoller at gmail.com, and then has the number. No persons, including members of the media, shall photograph, record, or otherwise visually capture the image of any witness, juror, or prospective juror, nor shall any person publish or disclose the name, identity, or personal information of any witness who is a minor, jury, or juror, or prospective juror. No person shall communicate or attempt to communicate with any witness, prospective witness, juror, or prospective juror prior to the return of a final verdict. No interviews of witnesses, jurors, or prospective jurors shall occur until after the conclusion of the trial and only if voluntarily agreed to by the person. Photography, video recording, audio recording, live streaming, and any other form of recording or transmission of courtroom proceedings is strictly prohibited. No cell phones or other electronic devices will be permitted in the courtroom. Electronic devices may be permitted in the courtroom by the media for note taking purposes only, subject to approval by the court, and must remain silent at all times. No media interviews shall be conducted in the courtroom, in the hallways, or in any security restricted areas of the courthouse. All interviews must take place only in designated areas approved by the court and coordinated with the assistance of the court appointed public information officer. Media activity must not interfere with courthouse operations, security measures, or the orderly conduct of proceedings. All persons present in the courtroom shall remain silent and respectful at all times. No talking, gestures, facial expressions, emotional outbursts, or any reactions to testimony, rulings, or proceedings shall be permitted. No reading of newspapers, books, or other material unrelated to the proceeding is allowed. No food, drink, or chewing gum shall be permitted except as authorized by the court. All persons attending the proceeding must be dressed in appropriate business attire. Clothing or items displaying messages, logos, symbols, or images related to the case or that are otherwise distracting or potentially prejudicial are prohibited. Hats, caps are prohibited. No signs, banners, or demonstrative materials may be brought into or displayed within the courtroom or courthouse. No members of the public or media shall be permitted beyond the bar separating the gallery from the inner section of the courtroom. That area shall be limited to counsel, parties, court personnel, law enforcement officers involved in the case, witnesses when called, jurors, and other individuals authorized by the court. The trial shall be conducted in a secured environment. All persons entering the courthouse shall be subject to security screening, including magnetometers and searches of personal belongings. Additional security measures may be implemented as deemed necessary by the Collin County Sheriff's Office, other security personnel, or the court. No weapon of any kind shall be permitted within the courthouse. Members of the public and media shall not congregate in the hallways, entryways, or other areas of the courthouse in a manner that disrupts operations, creates security concerns, or interferes with the movement of individuals. All persons must comply with the direction of the court staff, security staff, and law enforcement personnel at all times. Order prohibiting extrajudicial statements or gag order signed July 28, 2025 will remain in force until the completion of the trial or until further order of the court, order is attached for reference, as stated in the order. As stated in the order, any violation may result in contempt, fines, attorney discipline, or other remedies as the court deemed appropriate. Any exhibits omitted during trial should not be released to the public or media until the conclusion of the trial proceedings. Finally, as reflected on the attached map, the court has designated certain areas around the exterior of the courthouse as restricted access. These areas, colored in red, will be secured for the courthouse operations, and security will not be open for use by the general public or the media. Furthermore, an individual or group shall not assemble or congregate in areas that block ingress or egress of vehicular movement or pedestrian traffic. Any individual or group engaging in speech activities on Collin County premises shall at all times comply with applicable federal, state, county, city, or other local laws, statutes, ordinances, regulations, or rules as detailed in the attached map. Collin County Courthouse, located at 2100 Bloomdale Road in McKinney, Texas, shall be under a temporary curfew beginning May 31st, 2026. The curfew will be from 11 p.m. to 6 a.m. every day until further order of the court. Curfew means the designated time after which access to or movement within the entire Collin County Courthouse campus, including parking lots, sidewalks, green space, or any other designated areas, are restricted from access. Any violation of this order may result in immediate removal from the courtroom, courthouse, or courthouse grounds, and may result in revocation of media credentials, access, and the imposition of sanctions, including contempt of court. No warning is required prior to the enforcement of this order. The Collin County Sheriff's Office and other designated law enforcement personnel are ordered to ensure compliance with this order at all times during the trial. This order may be modified at any time as necessary to ensure the fair and orderly administration of justice. And this was signed on the 18th day of May by Judge Roach. And then this is the area that they were speaking of. All right, so pretty much nobody can be in this particular area. Anything that was marked red, that is the restricted security perimeter. All right, so let me go back, and I'm just going to keep this up on the screen. So, with that being said, let's go into the Waller. Okay, let me give you guys a little refresher what the Waller actually requires. So, quick refresher, because I know we covered this before, but it is worth repeating under Waller versus Georgia. Closing a courtroom, even partially, to the public requires four things. One, an overriding interest likely to be prejudiced. Two, the closure has to be narrowly tailored, not broader than necessary. Three, the court has to actually consider reasonable alternatives. And four, the court has to make specific findings on the record, aka on the record, okay, not off the record in the judge's chambers, but they have to make specific findings on the record justifying the closure. If you guys tapped in to the three Supreme Court, not Supreme Court, the three appellate court readings opinions that I did, you will understand what I meant when I said that you have to put it on the record. Okay, so you have to justify why certain members of the public or family cannot get there, or why you're closing part of the courtroom to certain individuals. All right, if you miss any one of those four, and under Texas law, that is called structural error. And that means the conviction gets reversed automatically. No separate proof of harm is required. I'm going to read that one more time. Miss any one of those four, and under Texas case law, that is considered structural error. And that means that the conviction will get reversed automatically. No separate proof of harm is required. Now, let's look at the restrictions. The courtroom opens at 8:30 a.m. Media gets in starting at 8:30. Family at 8:40. General public 8:50. Only 9 media members allowed at any one time. Public seating is space available only. The doors close promptly at 9 a.m. And if you're not in by then, you're not getting in until recess. And then once you're in, there's no leaving or coming back except during recess. Then there's the recording restrictions. No photography, no video, no audio, no live streaming at all. There was no exception to that. No cell phones or electronic devices permitted, period. Now, media can bring devices, but only for note taking with the court's approval. And beyond the courtroom itself, there is a curfew on the entire courthouse campus, 11 p.m. to 6 a.m., and an exterior access map with restricted red zones that I just showed you guys. And then on top of that, there was a dress code. So if you wasn't business attire, they're going to ban anybody who had hats, logos on their shirt, whatever the case may be. Now, here's where it gets pretty interesting. So, we are going to apply the Waller factor by factor since he put in and he cited himself Waller versus Georgia. Let's take a look at Waller and let's run that 4-factor test. Because remember what I said. If any of those one, if it, you miss one, if you miss one of those tests, that is considered a structural error. The conviction is going to get reversed automatically. First thing first, factor one, overriding interest. The order states the case has generated substantial public and media attention, and that unrestricted access may compromise courtroom security, jury privacy, and the defendant's right to a fair trial. That's what it said. That's the language. But here's the problem, that is generic. It's kind of a boilerplate that could be a copy and pasted into a high profile case, right? And we've already seen Texas courts in my last, if you have not caught that video, the last video that I did, the 3 Texas cases that were reversed, definitely go see that. And in those videos, we saw the Texas appeals court and the Texas criminal appeals court reject exactly this kind of language. Stedman versus State, the foundational case from the Court of Criminal Appeals, that's the one where how can I say this? The ex-offender of a minor. That was the foundational case. And it specifically requires specific concrete facts tied to this particular case, not general concern about public interest. Factor number 2, narrow tailoring. This is where I think the order overall is the weakest. There's no explanation anywhere for why the number is 9 media members specifically. No explanation for the staggering entry times, and most importantly, there's a complete ban on live streaming and 0 alternatives offered. Now, compare that to William versus State, the case that actually survived a public trial challenge. In Williams, one spectator was physically excluded. Remember, it was, oh my gosh, what was the name? I forgot what the name was, but it was one spectator that was physically excluded, but the court let them watch a live stream from another room. That alternative viewing option is exactly why that court called the closure trivial and let the conviction stand. This order doesn't offer the safety valve to anyone, not excluded media, not excluded family, not the general public. Factor number 3, considering alternatives. Presley versus Georgia puts the burden on the trial court, not the defendant. So to think through the reasonable alternatives. The judge has to think through the reasonable alternatives. Things like reserving specific roles for the public, splitting sessions, or even setting up an overflow room with an audio or video feed. Nothing in the order that Judge Roach issued reflects that any of that was considered. It goes straight to the capacity limits and a locked door. That was it. That was all. Factor 4, specific findings. So the same issue that we saw in Stryker, I keep saying, I don't know if it's Stryker or Stricker, it's one of those, Hernandez and Stedman. Now remember, Stryker was the one who was stealing from her boss or his or her boss. I think her name was Jennifer Jo Stricker, so it was a female. The PayPal, she was transferred from the boss PayPal to her PayPal. Hernandez was the one who unalived during a robbery. He unalived someone, and then Steedman is the individual, the pedo. I'm gonna say that. But the same issues that I just spoke about, we saw them in those three cases. And the findings in this order are policy level statements, not findings specific to this court's actual dimensions, this actual veneer size, or a documented particularized security threat. Steedman required things like actual seat counts and a specific factual basis for a security concern. Here, there have been an unrelated real threat on record. Based off of the affidavits that were submitted, there were no threats. This order doesn't show the same level of specifics. And here's the part that stands out to me after reading all of this. In Stricker, Hernandez, and Steedman, the three cases that we went over, the closures were all limited to jury selection or voir dire. This order governs the entire trial, not just portions of it, but the entire trial. That's a broader scope of closure than any of the three cases that already resulted in the reversal in Texas this year. And the triviality doctrine, the escape hatch that saved Williams, doesn't help here either. Steedman and Cameron both say closures during jury selection specifically can never be trivial. And this order isn't limited to voir dire at all. Now, an important caveat, because I don't want to overstate this. A weak order on paper does not automatically win a motion for a new trial. What actually matters is how this plays out in practice, whether the public was generally excluded, whether the media cap created a real bottleneck, whether any of this actually prejudiced the defendant's right to a fair trial. This order is strong evidence for the defense's argument. It's not a ruling in their favor. I'm going to do another video where I read all of the affidavits so that way you guys can have a clear understanding as to why the appeals team is going after this structural error. Because this order that I just read excluded people the media, some members of the public, even a family member from parts or in the whole trial in its entirety. And that alone can flip this. Now, I'll keep tracking this new trial motion as it moves through the court. But remember, under Texas Rule of Appellate Procedure 21.8, the court, the trial court, not the appellate court, but the trial court has until roughly 75 days after sentencing to rule, or it's deemed denied. And that puts us at August 23rd. So we are going to be watching that. So follow me. Make sure you're subscribed to my channel so that way you don't miss a thing. All right. And drop a comment below if you want me to break down the gag order. Because it is referenced in the same docket, but in the same document. But drop a comment below if you want me to speak more on that gag order, because there is a lot of stuff that people are saying, well, he da 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 da, the gag order didn't apply because the trial was over. But let me know if you want me to cover that, okay? All right, until then, I'm Cassandra, your favorite paralegal, and this is like Legal Doc Talk. Y'all have a good night. Bye.